Each year, law enforcement agencies across the state of Texas make tens of thousands of arrests for driving while intoxicated offenses. Reporting the arrests, prosecutions, and the dispositions into the computerized criminal history system is the responsibility of law enforcement agencies, prosecutors, and court clerks. The contributions of each agency are essential to the effective operation of the computerized criminal history system and criminal justice agencies. Law enforcement personnel depend on the arrest and disposition information contained in criminal history to correctly charge a subject that has been arrested. Prosecutors need the information to take legal action. Courts need the information to properly impose sanctions that fit the crime. Statutory requirements set the precedent for law enforcement agencies, prosecutors, and court clerks to report certain case information. Chapter 60 of the Code of Criminal Procedure requires that information on arrests, prosecutions, and dispositions for subjects arrested for Class B misdemeanor or greater violations of statutes be included in the computerized criminal history system. Police departments, sheriff's offices, and any other criminal justice agency that arrests a subject for a Class B misdemeanor or above are required to report the incident to the Texas Department of Public Safety within 7 days after intake, using either live scan or paper forms. County attorneys, district attorneys, or any other prosecutor receiving a Class B misdemeanor or greater offense must report to the Department of Public Safety within 30 days the decision to accept, reject, change, or add the charge for trial. Courts that try Class B misdemeanors or greater offense cases must report the dispositions to the Department of Public Safety within 30 days as well. Both have the option of submitting the information using paper forms or electronically through the Criminal Justice Information System. Complete and accurate reporting is beneficial to criminal justice agencies by providing case information that is required for agencies to properly charge, prosecute, and sentence subjects that have and continue to violate the law. When information is missing from criminal history records, it hinders the actions of criminal justice agencies. Take, for example, a subject that is arrested by law enforcement authorities for driving while intoxicated. If the subject has been arrested multiple times for that same offense, but no convictions have been reported, the subject will most likely be charged with a first offense, unless the law enforcement agency or prosecutor follows up with those agencies that failed to report the information. Criminal history records that fail to show prior arrests or dispositions are typically the result of one or more of the following actions. The arrest information was not received by the Department of Public Safety. If the county reports electronically and reported the disposition but not the arrest, the disposition may be in a suspense file. A suspense file is one that stores disposition information of cases when the arrest information cannot be found in the system. If the county reports on paper, DPS would have returned the form to the Criminal Justice Agency requesting fingerprints and the arrest information. 2. The disposition was received but an error exists in the record. When this occurs, the Department of Public Safety will return the documents back to the reporting agency for correction. An example of an error in the record is coding of fines and court costs to include dollars and cents. The correct way to report fines and court costs is in whole dollars. 3. The Department of Public Safety has not received the disposition. To reduce the incidence of missing records, the state of Texas amended Chapter 60 of the Code of Criminal Procedure to include a data reporting improvement plan. This plan requires that any county having an average disposition completeness percentage of less than 90% to establish a data advisory board and prepare a data reporting improvement plan. These actions are taken to ensure that the county carries out the necessary steps to improve their average disposition completeness to be equal or greater than 90%. The The Data Reporting Improvement Plan must include comprehensive strategies to continue and maintain that level of completeness. Individual agencies must establish who within their organization is responsible for reporting case information to the Department of Public Safety, and in the event that party is no longer employed, who will resume the duty of reporting. Certain criminal justice agencies inherently have high turnover rates, and as a consequence, the lack in personnel resources can contribute to an oversight on the agency's part in reporting. Criminal history reporting is a county-wide effort. Communication within an individual agency, as well as between all the criminal justice agencies in the county, can foster arrest and disposition reporting by allowing others to be aware of the needs of their department, agency, and of the state law requirements that must be met. Criminal justice agencies depend on you to report arrest and disposition information. If you need assistance or help with reporting, contact the Department of Public Safety Crime Records Service, and a field representative can assist you. Thank you.